Court calls the case, People versus Sean Odom.
Good morning, Your Honor. Brandon Bird on behalf of Sean Odom, PA 3734. Mr. Odom, can you please state your full name for the record?
Sean Martell Odom.
Thank you.
You're welcome.
Yes, sir.
Respectfully, Your Honor, I did get it. I know I got a motion for adjournment in there right now, but I did get a chance to speak with my client, and he'd like to set this matter for exam. I did get all discovery in this matter.
So all discovery is complete.
As far as I know, yeah.
People have their witnesses available the 13th.
We'll try next, Your Honor.
Preliminary examination in person, May 13th, 2025, 9 a.m. before me. Bond will continue.
To address bond, yeah.
Go ahead.
Client, 40-year-old, 6 kids, 2 of them are grown. He helps raise them all. Lifelong resident, Your Honor. He is employed. He's trying to get back to being able to support his kids in this matter. I do understand this is a domestic violence third offense notice. My client indicates to me that he came in contact with the police because he actually went to the police station to file a report on the complaining witness. The complaining witness showed up to his job, and because the complaining witness showed up to his job, that was counted as contact. As soon as that matter happened, my client, out of his own volition, called his probation agent, to see what he should do. Probation agent told him, go to the police department and put in a report. When he put in that report, he turned around and got arrested in this matter. I do believe he was arraigned on his probation violation, in which he indicates to me that he received a $100 bond in that matter. I'm not definite, but I'm pretty sure the court probably knew about this case when they gave him that $100 bond, because this case stems back from March 28th, Your Honor. Respectfully, my client understands no contact with the complaining witness. At this point, he doesn't want any contact with the complaining witness. He didn't want contact with the complaining witness when he came into contact with her at his job. So respectfully, we're just gonna ask for a personal bond. My client doesn't mind the tether if we have to do a tether. This is a relationship where both of them need to stay apart from each other. He was doing his due diligence to stay apart from her. And just respectfully, Your Honor, we're requesting a lower bond, hopefully a personal bond, so he can at least get back to work and take care of his children, Your Honor.
Response.
Your Honor, I would strongly object to any change in his bond. I believe it's set at 50,000 cash surety at the moment. Mr. Odom has a lengthy history of dismissed DVs as well as DV conviction from just this year with the same victim for a DV second, which was pled down. He's currently on probation for that and violated his probation for getting this new case. In the report for his bond violation, the victim informed officers that she let him borrow her car because he had nowhere to stay. She asked for the car back. He came back to her house and was yelling at her. And she also stated that he pulled out a knife while he was there. So I have great concerns that he can't follow court orders and wouldn't keep getting in contact with the victim and wouldn't be able to stay away, given that he's already on probation for domestic violence with the same victim.
Yeah, and there's ways to mitigate these circumstances. And the way we can mitigate that is with a tether. Is with a tether. Obviously, the
I don't know that a tether stops a knife, but go ahead.
I'm not saying the tether stops a knife, but at least it'll let you know. At least it'll let you know if he's around the complaining witness, and if he was there, and they could come get him right away.
And Your Honor, I did also want to make clear that previous case that was pled down was a previous FA with the same victim, and then in the underlying case of this case with the same victim, he grabbed her by her hair, pulled her into the living room, a fight ensued, and in the process of that, he hit her child in the face. He punched him, leaving him with a black eye. That's the underlying case that he was out on bond for. So I have great concerns.
And that he's still innocent unless proven guilty beyond a reasonable doubt to, Your Honor.
Motion for bond reduction denied. Bond will continue.
Thank you for hearing me out, you know.
Andrew Childers appearing on behalf of the people, Your Honor.
Kelsey Vergils with and on behalf of Theophilus Smith, who appears via Zoom. Mr. Smith, please state your name.
My name is Theophilus Smith, Judge Simpson, and I would like to speak. I would like to speak today because what's going on in this jail, Judge Simpson, is a prime example of the paper I wrote when I was at Michigan State University. Injustice.
Mr. Smith, I would advise you to not speak at this time. Mr. Smith, just let us handle the matter, please. Your Honor, I provided the court with an order. Mr. Smith met with the forensic center who deemed him incompetent but restorable. We have no objection to those findings and asked the court to give him time to be potentially restored.
Any additional information from the people?
No, Your Honor. The people would stipulate to the report as well. Thank you.
All right, court upon reviewing the report would find at this time he's incompetent to stand trial, but likely to attain competence provided the course of treatment. Given that, the court will sign an order to that effect. And I've signed that order. I will adjourn this for a competency review to 90.
Judge Simpson.
I'll set a competency review for July 30th. July 31st, 2025, 9 a.m.
Okay, can I speak with you now, Judge Simpson?
Mr.
Can
Smith,
you what?
I need to speak with you because I need to ask you some questions. I know they deem me incompetent, but Judge Simpson, my safety is at threat in this jail. I'm strong. Judge Simpson, they've been breaking me down mentally, physically. They've been stripping me of my dignity. The COs and the inmates are in cahoots.
Okay, Mr. Smith, Mr. Smith,
I need Judge.
okay, just listen, hey,
Judge Simpson.
hold on.
Yes.
I've given you another date. You're gonna get a chance to come back and talk, okay?
Yeah, because they feel
But
like.
right now, you're gonna have to talk to some other folks.
I'm out today, you said, Judge Simpson?
What'd you
Judge
say?
Simpson, excuse me, sir? Yeah, I'm strong. I'm out today.
No, not today.
Mr. Smith, you're gonna,
Judge Simpson, what this jail is doing, they trying to attack Judge Simpson. Believe what I'm saying.
Mr. Smith, you're gonna get some mental health treatment. Please call the public defender's office.
All right, Mr. Smith, contact your attorneys and we'll see what we can do, okay?
How long do I'm not even suicidal, Judge Simpson. They got me in the.
All right, Mr. Smith, I'm done.
Judge Simpson.
Thank you.
I don't do nothing about my.
Thank you, Mr. Smith.
I can't even call my mom. They got me in the suicide.
Court does call the case, People versus Amanda James.
Andrew Childers appearing on behalf of the people, Your Honor.
And good morning, Your Honor. May it please this honorable court. Oh, well, I'll yield the floor to someone. Oh, okay. Good morning, Your Honor. For the record, Rita Young appearing on behalf of Miss Amanda James, who is present and standing to my right. And today is the date and time set for a probable cause conference, Judge. And there has been an offer made. I don't know if the court's received the printout yet.
I have. I've received a plea sheet that indicates she's going to be pleading to 3 misdemeanor charges.
Yes, Your Honor.
The stated count 3 of operating with the presence of a controlled substance, the crime of operating either with no license or multiple licenses, that's count 4. And then also an added count 5 of use of a controlled substance, a 1-year offense. On her successful plea to those guilty plea to those charges, counts 1 and 2 would be dismissed. That is the court's full understanding of the agreement.
And Judge, there was an agreement by Mr. Childers and myself that she could be sentenced under 7411, but the plea form indicates it's only applies to count 5, and I asked that he agreed that it also apply to count 3, which is the presence of.
And Your Honor, it can't, as the court's aware, it can't.
Yeah, I didn't.
7411 doesn't.
I don't think it can.
Very well done, Your Honor. I believe that my client wishes to proceed with the offer. She has been
Did
advised.
she sign an advisory form?
No.
All right. You sign one. With
Yep.
Let's have her sworn.
Raise your right hand. You solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth.
I do.
State your name.
I'm Anthony.
Ma'am, it is this court's understanding that you're going to be pleading guilty to 3 charges. Is that your understanding?
Sure.
All right. First of all, that you'll be pleading guilty to the charge of operating with the presence of a controlled substance. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. The court could also order your vehicle mobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes.
All right. Also, then count 4, operating with no license or multiple licenses. That's a misdemeanor punishable by up to 90 days, $100 fine plus court costs. You understand that?
Yes.
And then also the added count 5 of use of a controlled substance. That's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that?
Yes.
You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge and you'd be sentenced before Judge Barr in the 14A2 District Court. You understand?
Yes, sir.
All right. Now, understanding all of that, ma'am, do you still wish to plead guilty to these charges?
Yes, sir.
To the charge of operating with the presence of a controlled substance, how do you plead?
Guilty.
To the charge of operating with no license or multiple licenses, how do you plead?
Guilty.
To the charge of use of a controlled substance, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights for every day, is that correct?
Yes.
Any question regarding any of those rights?
No.
All right, look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights that are on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes.
because you believe that you're guilty of these charges?
Yes.
On February 9th, 2024, at the location of Ann Street in the city of Ypsilanti, Washtenaw County, state of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, had you ingested a controlled substance?
Yes.
Was that cocaine?
Yeah.
All right. Were you stopped by the police or was there an accident?
I was approached by the police while airing my tire. I'm not sure if they seen me exiting my vehicle prior to them approaching, but
They approached you because there was no air in your tires?
I was pulled over on the side of the.
Side of the road because your tire had gone flat? Okay. And after they approached you, were you ultimately arrested?
I was detained, yes.
Pardon?
Yes,
All right. Were you taken to the hospital for a blood draw?
yes,
Did that blood draw show the presence of cocaine and or its derivatives?
yes.
All right. Do you have any reason to dispute those blood test results?
No,
All right. And at the time that you used the cocaine, you knew what you were using was cocaine?
yes,
Pardon?
yes,
All right. And at the time also that you operated the motor vehicle, did you have a license?
No.
Okay. Never had a license?
I've had a license, it was just
But
suspended.
at that point, had no license.
Correct.
Correct. All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
The people.
Yes, Your
are
Honor.
satisfied, Your Honor.
Court will accept the defendant's pleas of guilty to counts 3, 4, and 5. Counts 1 and 2 are dismissed. Pre-sentence investigation and report as well as screening assessment is ordered at 14A2 probation. Sentencing will be May 14, 2025, 10 a.m. before Judge Clark.
May I address bond, please?
Can I stop you? No, go ahead. You
Of course you can.
can.
Miss James, she's 45 years old, Your Honor. She resides at the address that's listed in her file. She's a certified nurse assistant and provides home care to a patient that she's had for 7 years. Her bond is currently set at 10,000 cash or surety, and that was because she appeared by Zoom for probable cause. No, she appeared by Zoom for an arraignment and then thought she could appear by Zoom for the probable cause conference, was told that she could not make it to court in time. Her attorney was not able to get a new date, so the bond was increased to $10,000 cash or surety. We're asking the court to please reinstate her $5,000 personal bond, which the court set on July 9th of 2024.
How did she come into custody?
Driving without license.
When the police came into contact with her, when she had pulled over and was filling up the tire on her
No, just recently.
car.
No, but then
When were
she,
you arrested the last time?
how did she just
just brought
recently
in.
come into custody?
I was-
She didn't come immediately back to the court.
Yeah, no, I was in a vehicle.
No, Your Honor, she did not. She said that she thought that her attorney at that time would be able to get her a new PCC date, but then her attorney withdrew. And then I was assigned on January, I think it was 9th of 2025. And then that's when she had been taken into custody around sometime in January.
No, I just came.
No.
No, I was in a vehicle that was pulled
So,
over.
and it was pulled over.
Yes,
And you knew at the time that it was pulled over that you hadn't shown up for your court date.
yes, I
So
didn't.
why didn't you come in?
Well, I did. I came in
Well,
with that.
now, yeah.
Yeah, well, at the time prior to me being pulled over, the attorney I had, Chelsea, I can't think of her last name, she's a public defender. She advised me originally, I was on the phone
She
with her
advised you originally.
to not come, to not turn myself in.
Oh, really?
She did, and then
She
she
did?
quit.
So she told you,
And then
yes,
she-
don't come to the court
Until after Christmas.
until
I-
after
yes.
Christmas.
Yes, and then she quit.
Why would she say that?
For the same reason that she wouldn't tell you I was on the phone with her while she was here in court.
Excuse me? Oh, she was just out to get you.
I'm not saying she was out to get me. I'm saying that
She wanted
there
you
was
to
just
spend Christmas.
miscommunication. There was a
So
miscommunication.
she told you not to come in until after
She
Christmas,
told me to hold off on turning myself.
until after Christmas. Right?
Her words were,
I'm now on May 1st. When did you get picked up?
9 days ago.
9 days ago? That's well after Christmas.
Well, she had quit, Your Honor.
So,
I didn't
other
have
than the
enough-
other false statement you made about Mr. Shields, are you saying she told you to stay out till that point too?
I didn't have an attorney.
Oh,
I was informed by the.
oh, you're
Judge,
just put
I
on that
think she was-
advice? Yeah, okay.
Yeah, Your Honor,
I think
don't
she
wanna
was
make-
taken into custody before then because they would not have assigned me. I have proof that I was assigned on January 9th of 2025. So,
So where's she been since January 9th?
were you released and then failed to appear again?
I can explain to you after.
And then 9 days ago, she gets picked up.
Judge, it's kind of bizarre what's been going on.
Pardon?
It's a little bizarre what's been going
Oh,
on.
yeah.
with the Case,
have-
and we both apologize,
Yeah, okay.
but she has one prior conviction that was in 25 years ago,
Don't
Judge.
blame, you know what?
I'm not
Here's
trying
my
to
problem. I almost would buy your story, but
I'm not
you're
trying to
not
blame.
gonna blame Ms. Rios for you
No,
not
no,
appearing. You
I'm
decided
not.
that you wanted to stay out, you wanted to
I
be
did.
out till Christmas. She did
I
not
did.
tell you that,
no,
and then
I'm-
you just continued to stay out. So
Yeah, I'm not
motion
trying
for
to
bond
blame.
reduction denied, bond will continue. Thank you.
Very well, Your Honor, thank you.